Hello and welcome. Tonight, we're going to be working on Utah law. So, all of you people out there on the internet that are wanting to take the national information, this is for those students that want to take the Utah real estate license exam. So, this probably isn't your video. But for those of you that want the Utah license test, this is your video. And we're going to go through some questions tonight that are going to be very meaningful to you when you're in that situations, sitting in front of a computer, all nervous, wanting to get your real estate license. So this will be a big help to you, and we have a lot of videos that will help you folks out there in internet land get through a real estate exam for any state via the national portion, but this portion is for those students taking the Utah test. So we're going to go through about 15 or so questions that will be important to you. I'm Rick Roller. I'll be your game show host for the next hour or so. And on the other side of the computer, somewhere out there in the Ethernet or whatever it is Mr. Danny Naylor, who is doing all the technical work for tonight's program. Thank you, Danny, for being
Hey,
here.
Rick.
Number one, here we go. All right, exciting stuff. Once again, this is Utah law. So what we got, our first question is now going to appear on screen. It is the minimum balance of the Real Estate Recovery Fund. This is for the state of Utah, of course, at the beginning of any year for satisfying judgments rendered against the licensees is it 100, 200, 150, or 50? Well, guys, it's $100,000. 100 grand. Now, where does this money come from? Well, renewal fees, penalties that are assessed against individuals could be stashed in here as well. But as money is paid out, and this is paid out to consumers who were disadvantaged, um, then it's restored by individuals that receive payment out of recovery fund. They have to reimburse the fund, but it's also replenished quite regularly by the license fees that we all pay in the state of Utah. A little bit of that goes into the recovery fund. So, correct answer for number one is A, $100,000. Okay, that's the minimum balance. Could have more, sure, uh, but the minimum balance is mandated by state rules and regs. So, number two.
Hey, hope you're enjoying the video. Be sure to like and subscribe so you don't miss any more of them. And if you want even more review material, we have in the Prep My Exam link in the comments. We've got a plethora of practice exams. We have audiobooks. We have an exam simulator. We have everything that our students use to pass the exam on their first try. Okay? And if you want to get licensed in Utah, check out realestateonlinelearning.com and we'll hook you up.
Which of the following is not, see how not is real prominent there, a purpose for the Real Estate Recovery Fund? Education of licensees, well, no, that's one of the ones. Reimburse the public for damages, I already gave that away just a few moments ago. C, provide revenue for research and into real estate issues, yes. D, pay the travel expenses of the commissioners. Okay. Hey, that's the only one that doesn't sound reasonable. And if you're going, that is the correct answer. The money to pay the travel expenses of the commissioners does not come out of the recovery fund. Um, they come up with it some other place. Number three. Number three, please. Here we go. Number three, the maximum amount that would be paid from the Utah Recovery Fund for a single claim. Is it two, five, 10, or $15,000? Well, the max, two is too low, five is too low, 10 is getting there. The max, folks, is $15,000. Okay. So if there's a real estate agent out there who's been doing wrong to a lot of consumers, it would behoove your lawyer to get right after this, get a judgment from a judge, meaning that they rule that the agent was wrong, the agent has no money to pay it, the judgment that the judge rendered. Let's say it was, 10,000 or $15,000 or whatever it was the consumer wanted to get, and so you better get in there right away. Because if he's screwed one person over, he's probably screwed somebody else. Yeah. So, the maximum amount that we paid for recovery fund for a single claim is $15,000. And Anyway, number 4, please. Okay. So, what is the maximum that the real estate recovery fund will pay out to all claimants against a single agent? This is a guy that's done a lot of, nasty things for a lot of people and to a lot of people. And so you want to, like I said, you want to get in there right away because it's going to cap out. Will it cap out at 15, 30, 50, or $60,000? Well, 15 and 30, no, it's going to be C, 50,000 bucks. But if this agent's been out messing with a lot of people, that could be gone pretty quick. So get right on it. Okay, number 5. We're going to now talk about the state engineer's office, and they're very nice people. I've been up there a few times. They handle all the water rights. And so the Utah State Engineer's Office handles applications for real estate licenses? No. Easements? No. Liens? No. Well, guys, it's water rights. So it would be water appropriation, how these are divvied out, and how that all works. Okay. So number 5, Utah State Engineer, tie that in your brain to water rights. Licenses and that sort of thing, well, that's the real estate division. Easements and liens, that has nothing to do with the real estate division or regulatory agencies. Those are just, like private things that are put in public records and that kind of thing. When you get a loan from a bank, they want to secure it against real estate, they're going to file a lien. That's going to be filed in the public record. And easements are also filed in the public record as well. Let's look at number 6. That has nothing to do with the state engineer's office. Prior appropriation is a water law used in dry states like Utah to give first priority to whom? Well, it's given to the government, state government. Okay. And so what happens here is they're going to divvy those out on the concept of prior appropriation, where people come in and apply at the state engineer's office in the water rights division. And, it's first come, first serve. And that's how prior appropriation works. Those who got there early, the earlier water rights are actually worth more than the later water rights because they have a greater status. Number 7. Water, I mean, Utah's still considered an aquarian state. I mean, even though we don't have a lot of farming like we used to, I mean, we still have a significant amount. And so water rights are a really important issue here, especially for farmers and ranchers and the rest of us that like to eat. Number 7, in order to qualify for a water right, the applicant must demonstrate that the water will be potable, which means drinkable, used for beneficial use, available year round, stored under sanitary conditions. Okay. We'll throw that last one out. All right. So that gives us a 1 out of 3 chance. Potable, irrigation water doesn't necessarily have to be potable. Potable is much higher standard of water clarity and refinement. Irrigation water can just, you drill a well and put it through the sprinklers. But really, what they're driving for here is that if you want to qualify to get a water right, you have to show that it's used for beneficial use. And the highest use in our state, as I was alluding to a moment ago, is agricultural. The next after that would be industrial type uses. And then the last is potable or drinking water. But potable or drinking water doesn't take that much water as compared to these other types of uses, particularly like for agriculture. I mean, if you have to, even if you're watering your alfalfa fields, I mean, that takes a lot of water. Let's go to number 8, please. Okay, which of the following recorded water rights are not found in Utah, are not found here? Appropriated water in the form of stock ownership. Yeah. Sometimes water rights are owned by an entity, like a corporation or something, like an irrigation company. They own the water right and then they sell shares of stock. Uh, so you buy water shares from them because they own the whole water right. And that happens a lot. But we're looking for things that aren't found here. Water company rights in the form of shares, okay. Appropriated rights attached to a deed or water riparian rights attached to a deed. Well, okay. Which one are you not going to find here? It's going to be number D. Okay, water riparian rights attached to a deed. Um, and I can't give you a really good example of that. But appropriated rights attached to a deed, water riparian rights wouldn't be attached to a deed because we don't use riparian water law. We use prior appropriation. So I guess that's why there's a conflict there. So it's definitely not going to find that in Utah. Okay, well, if you're not thirsty by now, you will be by the end. Let's go to number 9. Speaking of clear, beautiful water, all the following can file a mechanics lien except material men. They're the people that supplied the like sheetrock or the carpet or whatever it was used to put into a property. Real estate agents, architects, and subcontractors. Well, material men, architects, and subcontractors all have the right to put mechanics liens on a property, but real estate agents do not. And the reason why is because we don't do anything to improve the property. Material men, they provided the materials to build the property or to remodel it or whatever. Architects, their work was key in getting things done on that remodel or maybe a new construction type project. And subcontractors, absolutely, they're working and making it all happen. Real estate agents do not have the right to use mechanic lien rights. We don't do anything to improve the property, so we're not included in this list. Material men, architects, and subs will obviously, and also general contractors, but not real estate agents. Okay. If you try to use a mechanic lien law to enforce your commission, uh, you're going to be in real bad trouble with the commissioners. That's just something you cannot do. I mean, you can always sue. You can get a lawyer and sue for your commission, but you don't have a mechanic. You're not covered under mechanic lien laws at all. We don't do anything to improve the properties, guys. Number 10. Moving right along to our next question, number 10, and it says, mechanics liens must be filed within how many days after notice of completion on a project listed in the state construction registry? Okay, is it 120 days, 10 days, 20 days, or 90 days? Well, 120 is a little bit long, 10 and 20 is a little bit short. So if you're heading for 90, your instincts are wonderful. 3 months. Okay. So where do you file them? Well, if you're getting familiar with mechanics lien law, these are going to have to be filed in a appropriate place. It's going to be a lawsuit, so that would be a court, wouldn't it? Um, if you're trying to enforce them, let's look at number 11. Help too. Number 11 talks about the notice of liens. How many days following a notice of lien does a contractor have to take the matter to court? Okay, well, you're not going to wait too long. 365 seems like a little long. I hope you would feel that way. And 30 is probably too short. And so it's either going to be 180 or 90, and if you're leaning towards 180, about half a year, 6 months, uh, your instincts are right on the money. Okay. So how many days following a notice of lien does a contractor have to take the matter to court? About a half a year, 6 months. And that can come and go pretty quickly, but you got to get everything ready to go. And um, once you file a mechanics lien, you'll probably enter into some serious and fast negotiations, particularly if there's a sale pending and whatnot, because there's no way they're going to want this thing tied up, in a court. And by filing a notice of lien, you're also putting a cloud against the title. So, you first of all, you better have all your ducks in a row to file the lien. because there are penalties for slander of title. But how many days following notice of lien? You got a half a year, and probably wouldn't just by filing the lien. You're gonna tie up you put a cloud on that title, because no title company is going to insure that title when there's a mechanics lien filed against it. They're going to require that that be taken care of. Number 12, please. The owner of a project should obtain which of the following in conjunction with any payment to a qualified mechanic on a construction project? Now, it might be the owner of the project, okay, or it might be your general contractor or your sub, that's working through this. But if you want to be dang sure that you're clean of all these liens, then you probably want to get involved with some of this just to make sure that it's done correctly. So, what is it that you want to get? Well, obviously, what you want to get is a lien waiver release. It's not a notice of commencement. I mean, that means that they started work. That's okay. I mean, but that's not going to protect you just knowing that. A certificate of completion. They're going to file a mechanics lien because they didn't get paid, not because they didn't finish the job. They probably finished the job and just didn't get paid. Notice of lien claim. That sounds pretty good, but it's not something you do. Okay, because what we want here is the owner of the project should obtain what to make sure you're clear of these potential liens. A lien waiver release. It's A. A. The problem you have is sometimes subcontractors aren't paid by the general contractor, and you got to have trustworthy general contractors because if you end up in a situation where they didn't pay their material supplier bill or they didn't pay a sub, it's going to come back to haunt you, and it's going to be real tragic because you paid the contractor. Maybe they misbid on the project and it cost more money than they anticipated to make it work. So they ran out of dough. Maybe that's something. I don't know. But, for whatever reason, you need to use experienced, good general contractors. And you don't have these problems, but that doesn't mean new people can't do it. That doesn't mean, all kinds of people can't do it. But it's not just the ability to put things together and coordinate work crews and pound nails and make sure supplies are showing up on. There's a business side of this as well. Making sure people are paid and permits are pulled correctly and whatnot. So being a general contractor is a huge responsibility. Get someone experienced and someone that really knows what they're doing, or work with someone that's newer. That's okay too, but you're going to want to make sure that they follow through. It's one thing to pay for your house and get it all done. It's another thing to find out later that the subs didn't get all paid, and it's really a mess. And sometimes, you know, um, the title insurance can help out with some of that stuff, but you have to be on top of things. Number 13. An agent can transmit contracts by email or other digital delivery services as long as the other agent agrees, their clients agree, their broker approves, the Division of Real Estate receives a copy. The Division of Real Estate doesn't want a copy of all your deals unless they ask for it. And that's because they're starting an investigation. But, I mean, good grief, come on. I mean, 30, 40,000 agents in Utah. They'd have to have another whole building and staff to look at all the different contracts. No, that's not what they're all about. Okay. So in this one, the other agent, they don't have anything to do with this. It's the client you're working for. Okay. Now, maybe you were leaning towards their broker approval, but really what we're looking at here is your broker's not going to get involved at this stage of the game at all, probably. I mean, you're putting this deal together and your broker's trained you. They're there to help you. They will guide you and direct you if you have questions. Um, And maybe on your first deal or two, I don't know, maybe they'll be there to help you put it all together just so you get the hang of it. But anyway, for this one, number 13, our correct answer is the clients have to agree to it. And that's generally they do, particularly if there are people that are out of town or they're busy. So that works either way. But getting documents and using things and programs like DocuSign are very efficient in getting deals done, particularly when you're working with out of town buyers that are coming into town, and it's very efficient. Let's look at number 13 now. An agent can transmit. Oh, we already did this one. Yeah, that clients agree. So now we're on number 14. Okay, which of the following requires that any agency agreement? Which of the following requires that any agency agreement be in writing and signed by all the parties? Is it the statute of frauds? Is it the doctrine of prior appropriation? Prior appropriation has to do with water rights. The Dodd-Frank Act, oh, that's about lending. The Association of Realtors, oh, that's our private club, that is maybe getting involved more with realtor regulations with some of the new things that are coming down. But on this particular question, guys, it is the statute of frauds. The statute of frauds is a uniform type agreement. That's pretty much the same in all states. But the Utah statute of frauds is our version of that. And the reason why you have these standard type agreements that are pretty much the same and across state boundaries, it just makes sense. I mean, people do interstate commerce all the time, and you live in, well, the largest owner of real estate in Utah that doesn't live in Utah, the largest state where they reside is California. And after California, you got Idaho and Arizona that, kind of run neck and neck. But there are more people in California that own Utah real estate than any other state in the U.S. And so it's nice that the statute of frauds in California is very similar to the statute of frauds in Utah. It's one of those uniform agreements that are pretty much the same across state boundaries, because people do commerce across state lines all the time. Number 15, leases must be in writing unless they are for less than 6 months, 1 year, 18 months, or 2 years. Well, guys, 6 months is too few, 2 years is too many. And 18 months, where the heck did that come from? Well, it's 1 year. Okay. So that's just right. So leases must be in writing unless they are for less than a year. So a year and a day or a year. Leases must be what? Written in order to be enforceable in a court of law. Now you can do, verbal 3-year leases if you want to, but if you have a problem with your tenant, it's going to be a he said, we said, kind of thing, and it's going to be a mess. As a landlord, your very best protection against erring tenants is a well-written lease agreement that you got them to sign, because you anything other than that, you're going to take in front of a judge, they're always going to favor the little guy, and that's unfortunate, but that's just the way it is. Okay, and a thought to end our program tonight, for those of you that are getting into business or already are into business, is that success consists of not getting, but of doing. Well, I thought success was all about getting. No, success is all about doing. Do the work. Show up. You can do this. Real estate's a great business to get into, and it will continue to be so because people love it. They want it. And most people want real estate. We don't have to talk them into buying real estate that much. We just have to find it for them and show them how to get it. So, yeah, tremendous business. Okay. Thanks for being with us tonight. It is our commitment to get you through the real estate exam with the least amount of trouble and the most amount of fun. So thanks for being with us. Thank you, Dan. See you guys next time.
Thanks for watching. If you want to show some appreciation to our instructors, be sure to like and subscribe so that they see how much you enjoyed it. And if you want any additional review material, check the links below for our full suite of practice materials for the real estate license exam. Thank you.